Cindy, do you want to just come back here and do them? We will do the oath of office one at a time, and then the meeting will be called to order following the oath. We will start with the newly elected mayor, Tom Funk.
Are we recording?
Yep.
Come up front, or how do you want to do this?
This will be yours. So you could raise your hand.
I,
State your name.
Tom Funk,
Do solemnly swear
do solemnly swear
to support the Constitution of the United States,
to support the Constitution of the United States,
the Constitution of the State of Minnesota,
the Constitution of the State of Minnesota,
and to discharge faithfully
and to discharge faithfully
the duties of the mayor
the duties of the mayor,
of the City of Victoria
City of Victoria,
in the County of Carver,
in the County of Carver,
the State of Minnesota,
the State of Minnesota,
to the best of my judgment and ability,
to the best of my judgment and ability,
so help me God.
so help me God.
And then if you could sign that.
Let's see, give,
They're all in different seats now.
Okay. Yours. And if you could raise your right hand. And I state your name.
I, Tom Bolt,
Do
do
solemnly swear
solemnly swear
to support the Constitution of the United States,
to support the Constitution of the United States,
the Constitution of the State of Minnesota,
the Constitution of the State of Minnesota,
and to discharge faithfully
and to discharge faithfully
the duties of the office of City Council
the duties of the office of City Council
of the City of Victoria
of the City of Victoria
in the County of Carver
and in Carver County,
in the State of Minnesota
in the State of Minnesota,
to the best of my judgment and ability.
to the best of my judgment and ability,
So help me God.
so help me God.
Tim's gonna read this. I,
Tom Gregory,
Tom Gregory,
do solemnly swear to support the Constitution of the United States,
do solemnly swear to support the Constitution of the United States,
the Constitution of the State of Minnesota,
the Constitution of the State of Minnesota,
and to discharge faithfully the duties of the office of City Council
and to discharge faithfully the duties of the office of City Council
of the City of Victoria
of the City of Victoria
in the County of Carver,
in the County of Carver,
the State of Minnesota,
the State of Minnesota,
to the best of my judgment and ability.
to the best of my judgment and ability,
So help me God.
so help me God. Thank you. Sign it.
I call the 9 January 2017 meeting of the City Council of the City of Victoria to order. First order of business is the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Okay, Lori, public announcements?
Thank you. I just wanted to issue an invitation to the Victoria Fire Relief Association Fishing Contest. It is held. Thank you. I didn't grab the flyer. It is the first Sunday. Thank you. It is February 5th from 12:30 to 2:30. Tickets are for sale through members of the fire department and I believe at Cabin Fever, and all are welcome.
Thank you. The agenda, can I have a motion to adopt the agenda if there's no changes?
I'll make a motion to adopt the agenda as written.
Is there a second?
Second.
All in favor, say aye.
Aye.
Hearing none opposed, the agenda is adopted. The next order of business is the open forum. This is an opportunity for the citizens of Victoria to come forward. Please introduce yourself, state your name and your address for the record, and go ahead and feel free to make any comments you wish. At this point, is there anybody that would like to address the council? Okay, seeing none, let's move on to the first order of business, and that is the organizational items. Lori?
Thank you, Mayor. Annually, there are a number of items that are prescribed either through city code or state statute that the city council needs to act on. There is a memo and a resolution included in the packet. Briefly, the items that should be addressed this evening are to appoint a mayor pro tem who can serve as parliamentarian and take over the duties of the mayor in his absence, to appoint the members of the EDA, to appoint the official newspaper. That recommendation from staff is to appoint the Chanhassen Villager as the official paper. The Villager has been the official paper of the city. The only other paper that would qualify at this time would be the Star Tribune, and staff researched that in 2016 and found it to be significantly more expensive. Also to adopt the official calendar. There is only one change proposed to the City Council official calendar for 2017, and that would be to move the second meeting in December to December 18th to avoid meeting on Christmas. The final item in the resolution is to appoint the official depositories and institutions where the city has investments and a checking account. I'm happy to take any questions at this time.
Okay, I'd like to make a few comments about the Chanhassen Villager. I don't think by statute we only have two choices: the Star and Tribune and the Chanhassen Villager. Is that correct?
Correct.
I know from the campaign cycle, I heard repeatedly when I was out there that there was a number of Victoria residents that believed that the Victoria Gazette was in fact the official newspaper of the city of Victoria, and that is not true. All of the official notices and the official newspaper, assuming that we continue and do what we've done in the past and select the Chanhassen Villager, that is the paper. One of the things that I would like to see done, and I think it's appropriate to discuss at this time, is that, in fact, that we limit distribution within city resources, which specifically means the front desk here at City Hall and the front desk at the Recreation Center, only to the official paper where all the official notices are posted. And I wanted to get the council a chance to comment on that and see if they agree with that. Council?
I disagree. If we're attempting to bring transparency to the city, the more distribution, the better. That's all I have to say.
So I'm not opposed to distribution, but I think that we should limit distribution to what the official paper is, which is the Chanhassen Villager.
What problem are we trying to solve?
Well, I think I think most people in Victoria understand that there's a clear bias in the Victoria Gazette. I don't think that's going to change. The editor of the paper is entitled to print what she wants without an issue. But the problem is, as I see it, it's doing a disservice to the residents of Victoria simply because of the fact that there's a lot of stories that are misrepresented and intentional misdirection that's put in that paper. And I don't think that we should be supporting that by distributing that on city property or putting that with the Chanhassen Villager. I think it sends the wrong message. We should focus on whatever the official paper is and distribute that at the city facilities.
I argued that exact same argument with respect to the Chanhassen Villager earlier last year when the same issues were showing up there related to your campaign and the Chanhassen Villager. My recommendation is we continue with both papers.
So today we have both papers.
Yes, today you can get the Chanhassen Villager, the Gazette, or the Lakeshore Weekly are dropped off here and are available for residents. The city doesn't pay anything to acquire copies of any of those.
So for me, it feels like there is also there's some fairly obvious bias in the Chanhassen Villager. And so I think clearly there's differences of opinion about the issues, and I think trying to silence opposition is pretty counter to the idea of a free press, and you're free to pick up and read whatever you want. I think it's absolutely disagree with the idea of deciding what people get to read or not.
Okay, so what I'd like to do is I'd like the council to be aware, after the edition of the Victoria Gazette came out 4 days before the election, on page 21 of that, there was what looked to be an ad put out by the editor that seemed to insinuate that the League of Minnesota Cities and the Association of Minnesota Counties were endorsing my opponents in the race. What I want to do is read into the record to make sure everybody knows. This is a letter I got from Tom Grunhofer. He is the general counsel of the League of Minnesota Cities. It's dated 16 December 2016. And it reads, and I quote, Dear Mayor-elect Funk, first, congratulations on your election. Thank you for bringing to my attention the Victoria Gazette article that appeared in the paper a few days before the election. As we discussed, while the substance of the article is essentially correct, i.e. that we will be filing an amicus brief supporting the city on certain issues involved in the pending open meeting law lawsuit at the Minnesota Court of Appeals, in the context of the pending election, the headline could be construed as suggesting the League of Minnesota Cities was supporting some or all of the incumbents in the election. As I mentioned on the phone, I want to assure you that the League does not, has not, and would not endorse any particular candidate in a municipal election. I have communicated with Sue Orson at the Gazette and asked her to clarify her position. I'm not sure what she's going to do with the information I provided her. In any case, I wish you the best as you assume office in January. Well, since that time, I have seen no retraction or clarification printed. Furthermore, also I want to read into the record, I got a note from Julie Ring, who is the Executive Director of the Association of Minnesota Counties. This is dated Friday, December 9th at 2:20 p.m. It's a copy of an email that she forwarded to me in which she sent it to Sue at victoriagazette.com. And she says in here, the subject is Association of Minnesota Counties in the City of Victoria. Hello, Sue. I am the Executive Director of the Association of Minnesota Counties. I am following up on an email you received from Tom Grunhofer at the League of Minnesota Cities. I was alluded to a headline in an article in the Gazette by one of my association members who felt it inaccurately suggested that the Association of Minnesota's counties was supporting the incumbent mayor and the council in their re-election bids. Like the League of Minnesota Cities, the Association of Minnesota Counties does not, has not, and would never endorse a particular candidate in a municipal election. The article includes a quote from the Association of Minnesota Counties that appears to be taken from a court filing. Our association is involved with the City of Victoria appeal to provide information to the Minnesota Court of Appeals about how its decision on open meeting law issues will impact counties throughout Minnesota. We were never contacted by the paper, nor did we communicate with anybody at the paper. Any assistance you could provide in clarifying our role in the case would be appreciated. Please let me know if you have any questions. Signed, Julie Ring. The reason I wanted to read this in is it's not just me. This is independent organizations that took the time, that wrote letters to me when I showed them what was in that paper. They had the same reaction to it that most others had, that was intentionally misleading. There's other issues with the paper that I think do a disservice to the residents of Victoria. One of which is over the past 4 years, myself and others have written letters to the editor, and none of them have been printed in the Gazette. Furthermore, when the Judge Kane issued her ruling in the open meeting law lawsuit on 31 March 2016, every newspaper in the area did a story on that, including the Star and Tribune, but yet nothing ever appeared in the Victoria Gazette, alerting the residents in Victoria who read that paper that the judge had issued a ruling. And then finally, the fact that the Gazette continues to put only out a one-sided point of view, and I expect it to do so further, will continue to mislead the public as to what's going on. As to the point about the Chanhassen Villager not being fair, I would disagree, and I would cite as an example that when former Mayor O'Connor put his statement in, the Chanhassen Villager printed that, and at the same time allowed the plaintiffs in the case to print a letter that provided our point of view. I will also point out that during this entire past 4 years where the lawsuit has been going on, not once has the Gazette ever asked any of the plaintiffs for our point of view. So again, I go back to the same basic point. The City of Victoria should not support a for-profit paper that has a clearly biased, one-sided point of view that I think does a disservice to the residents of Victoria. Other comments?
I call a question.
Go ahead.
I like the Gazette. I find it very informative and part of the community. It's a part of the fabric of this community. I would opt to maintain distributing the Gazette if it were as one person, one member of the council.
From my perspective, the Gazette's been here as long as I have, and it's been a long time. And I've appreciated the stories, particularly about our families, done stories about my grandmother, my parents, our families, did a story about Tim. Done some wonderful stories, and I appreciate that. I can never repair for those. However, during the election, there was, without a doubt, a bias. I don't think anyone would question that. And that was disappointing. With that said, there is value in the Gazette. I'm just curious, is there a number that we're talking about? How many papers are dropped off and how many are picked up?
I would look to my colleagues. I'll say the stack of Gazettes is maybe this big. And I understand that the mayor has arranged for 40 copies of the Chanhassen Villager, and the Lakeshore Weekly is probably a similar stack.
Okay.
Less than 50 copies of each paper, I would safely venture.
Okay, any further comments? I'd like to offer one other possible option here for the council. I'm not opposed to the Gazette being distributed. What I'm saying is I don't think it should be on the counter, since it's not the official newspaper, that we need to separate them. If we want to set up something in either public location, being the rec center or the city hall, that businesses can post things, I'm fine with that. The Gazette is a for-profit paper, and they would be able to, I'm sure we could arrange something where that and other businesses could post things that are clearly business-related. But still, as far as the official city paper, I think we should only be promoting one paper. And I also think it should be noted for everybody that's listening, everybody in the city of Victoria is entitled to get that paper for free. All you have to do is contact the Chanhassen Villager via email or by phone, and you can have that delivered to your house. So if there's not any more comments, the...
Point of order, please.
Go ahead.
With the attorney present, I'd like to ask the attorney a question. When a member of the council calls the question, what is the appropriate procedure?
Mayor and council, well, first of all, we're going to talk in a little bit about the mayor as a parliamentarian and can turn to me for questions. I'm happy to give input on that, Mayor, if you want me to respond to that.
Please do.
Typical process. And I will concede that I am not a Roberts Rules expert. My understanding is, let me tell you my understanding, and then we can sit here and parse the Roberts Rules in front of us. A motion to call a question or a statement to call the question is something that's done by unanimous consent. That is, everyone consents to ending debate and voting on the motion. If there isn't unanimous consent to that, that request to call the question is put to a vote. So, I understand from Lori that that was done. There was a request to call the question. I believe that would have to be unanimous consent to end debate if there are other folks that have things to say about whatever the topic is, the newspaper or whatever it is.
So it should have been acknowledged from a procedural standpoint and put to a vote.
My view is that a call to question is a motion to end debate.
Thank you.
So is the appropriate follow-up then to second that motion and then call a vote, or how does it, I mean, procedurally, how do you walk through that?
A motion to end debate requires a second, and yes, it would be put to a vote at that point. If there's a second and there is no prevailing or superseding motion that's put to the floor.
Can you have a discussion after the second?
Certainly.
Okay.
I believe it's a debatable motion.
Okay, so the next step then is,
Motion on the floor to call the question.
Second.
so we ask for a discussion then?
Mayor, are you asking me?
Correct.
Unless I'm wrong about Robert's rules that it's a debatable motion, then yes, you would allow debate on the motion. And I'm scanning our summary of Robert's rules as we speak. But there is no harm to allowing debate, obviously, while I do that.
I don't have that there's a motion on the table yet. It's been just discussion. What I,
I'm sorry, I called the question. That is a motion.
So I am not an expert in Robert's Rules of Order. What is the procedure here? We've obviously already had the discussion. I think, unless there's further comment,
There should be a vote if there's no discussion.
Just to clarify,
Discussion is on the motion to call the question.
and what's the question?
The question is the original motion resolution before the council. I called the question to vote on the original resolution and end debate. So following Robert's Rules of Orders, there would be a second. If there is a second on that, we can debate whether or not we want to vote on it. And if it's at the end of that debate, we can vote then whether we want to end discussion. If we vote that down, discussion continues. If we approve it, the discussion is over and we're now at a vote on the original resolution. So at this point in time, in order to usher things along, there is a motion to end debate, there is a second. Now there is a discussion about whether or not we want to end the discussion on the resolution. And if there is no discussion, then we're at a vote on the original resolution.
Lori, if we go for a vote now, we're approving the items under number 5, organizational items and city council
So
packet.
the vote right now is to end discussion.
All right.
Yeah, so Mayor, if I may, I'm wrong. Our Robert's Rules summary indicates that if you're looking at the first page of it, or what is to me the first page of it in our little table, a motion to limit or extend the limits of debate requires a second, is amendable, and is not debatable. So the motion to end debate should not be debated. There hasn't been any yet, but so it should be voted on. And if the vote is in the affirmative, it requires by Roberts a 2/3 vote. But if it prevails, then there should be no more debate on the underlying motion, which is to approve the item before you.
All right, so at this point, the correct thing then is to call for a vote?
Correct, Mayor.
All right, and the vote would be to cease
debate.
discussion.
Correct.
All right, all those in favor of ending debate, say aye.
Aye.
Hearing none opposed, the debate's over. At this point, I believe we need to have a motion to approve these items, right? And this would be, Lori, help me out here. This is approving the Chanhassen Villager as the official paper.
What we'd be looking for would be a single motion to approve Resolution 01-17. There is one item in the resolution that was not pre-filled, which would be a nomination for Mayor Pro Tem. So the first item I would suggest would be to look for a nomination and a second for Mayor Pro Tem, and then include direction to include that in the resolution.
All right, Bob, the correct procedure here for identifying somebody as Mayor Pro Tem and to discuss that is what? We can just have the discussion, or do we have to have the motion?
Yes, so Mayor and Council, you have before you what is in effect a proposed motion, a motion to approve Resolution 2017-01. There is a blank in that resolution, so there is a blank in that motion. And yeah, it would be appropriate to, I guess it would be another subsidiary motion to add to that resolution a name that's agreeable.
All right, so I make the motion that we name Councilmember Gregory as Mayor Pro Tem for 2017. Is there a second?
I'll second it.
All in favor, say aye.
Aye.
Aye. All opposed?
No.
No.
Nay.
All right.
I move we approve Resolution 2017-01 and name Councilmember Tom Vogt as Mayor Pro Tem.
Second.
Now there's time for debate.
You've passed a motion to end debate on this topic. I guess if you want to debate the subsidiary motion, which is adding Tom Vogt, you could debate that.
I do. So we have to make a motion to be able to do that?
Nope.
All right, so I want to discuss that. I don't have any objection naming Councilmember Vogt as Mayor Pro Tem, but I do know that the history has been that up until this council took the oath, the mayor made the appointments for Mayor Pro Tem and for city committees. I have emails from 2012 and 2013 for the years of 2013 and 2014 that shows that the mayor at that time made the committee assignments and chose the Mayor Pro Tem. And so the question for the council is, if that's been the standard process before, why with this election are we going to change that process and take that ability of the mayor to nominate his or her choices for these positions?
That's an incorrect assessment of the past practice. Past practice was the mayor made a recommendation, looked for any comments, approval from the individual council members to, accept or not. So I also further would suggest that it has nothing to do with the election or the people involved other than level of experience. And so I think the mayor pro tem role is better served by somebody who has had some time on the council.
I'm not going to prolong this. It's not worth that, but I will provide anybody that wants copies, the emails that I'm referencing. These are public records that basically support the position that I'm taking, that the mayor in the past has made these appointments. So with that, we can close debate. Bob, how do we, at this point, can we just call for a vote?
Yeah, Mayor, again, in the past, you referred to the past practices. In the past, I don't know that we've hewed quite so tightly to Robert's rules. I think typically the mayor has called for a vote, and if anyone objected, they would have said that. So I think you can call for a vote if you'd like.
So I'd like to call for a vote without objections.
I'd like to have brief discussion.
Go ahead.
First of all, 1 year ago exactly, this would have been part of our meeting. Is that true? Approximately?
Correct.
Okay. So is the recollection that the mayor made a suggestion and then the council voted on it? Is that true?
May I respond, Mayor?
Please do.
I was here as part of the 2015 and 2016 processes, and council liaisons and mayor pro tem for those 2 years were assigned based on a rotating schedule. I don't know how that schedule was originally started. I have not seen the emails that the mayor is referring to, but in those 2 years, there was a rotating schedule that staff plugged people into.
I can add that the emails make reference to that, and in fact, that would be my intent under my administration, is we'd do the initial assignments and we'd rotate using the same process that's been used before. So I don't want to delay this anymore. Is there any more discussion with the council? If not, I move that Councilmember Vogt be Mayor Pro Tem for 2017. And that
Point of order, there is a motion already on the floor, and we need to vote on that.
which was the motion?
The motion was to approve the resolution with Tom Vogt as the Mayor Pro Tem. And there is a second.
All right, so we can just call for a vote? Bob, is that correct?
Yes.
All right, let's call for a vote. All in favor of that resolution signify by saying aye. Aye. Hearing none opposed, that resolution passes. All right. Lori, is that everything under 5?
That is everything under 5. Thank you, Mayor.
Okay, consent agenda. Council, is there anybody that would like to remove anything from the consent agenda? No? Lori, does the public have the ability to remove things from the consent agenda?
Mayor, the public does. Generally, what I would ask is that as you enter the council chambers, there is a paper form that can be filled out, and one of the items on there is which item that you would like to remove from the consent agenda. The typical practice then is to take that up immediately following approval of whatever remains on the consent agenda.
Perfect. So we didn't receive any of those tonight?
We did not.
So we can, I make the motion that we approve the consent agenda as is. Is there a second?
Second.
All in favor signify by saying aye.
Aye.
None opposed, the consent agenda is passed. Lori, council orientation, or Bob, I believe that you were going to give a council orientation?
Yes, Mayor and Council, Lori.
I'll just give a brief introduction. The memo that Mr. Vos is going to go over is included in the packet and will be added to the city website following this meeting under the city council section for those who would like to view it outside of the packet. What our intention is that Bob will lead the discussion walking through that memo, and as we reach the end of each sort of category, if the council has questions, I would recommend that we take those questions in line with each category to keep the discussion organized. And I've asked Bob if he doesn't mind if I interject, if I think of something that would be helpful and relevant, but otherwise Bob will be leading an overview of this memo.
Perfect. Bob?
Mayor, Council, so we're going to go over this new council member orientation. Just 2 or 3 preliminary remarks. Lori's right. First of all, your staff here does an absolutely fantastic, in my experience, probably the best city that I work with as far as doing PowerPoints. We had talked about doing this as sort of a PowerPoint and mocked something up. We're not doing it that way. I'm not as good as your staff at doing PowerPoints, first of all. But secondly, I think we do want to treat this as a conversation. So as we get to the end of a section, please do have an exchange with me and other staff about questions you may have. Secondly, this memo is of a form that is very similar to the form of memo we provide to all of our clients, 30-plus cities, anytime there's turnover in city council. It is also similar in form to a memo that was provided here a couple of years ago. There are some differences, though, and I don't want to ignore that fact. One sort of area of difference in this memo is that Lori and I talked about whether there were any additional areas that we might want to cover with you, and so we've added, I want to say just one, but it may be 2, but the one I know that we added was the very last about quasi-judicial decisions. That is not something that has appeared in prior memos that we've given to other clients, but it is worth talking about with you, 1. And then 2, I have, of course, updated this with the passage of time, changes in the law, and most notably the litigation that you are all familiar with, that former council and current council members are engaged in dealing with the open meeting law. That is an important topic for us to talk about. It is covered in the memo, and the fact of that pending litigation and the appeal from that is addressed in the memo, and that obviously was added. So it's not exactly the same as other memos that we've provided, but it's quite similar. The last point is, and I don't know if Councilmember Gregory or Mayor, if you attended or not, but the League provides new council member orientation type seminars or sessions, and the topics that they would cover or they have covered with you are probably very similar. We are not reinventing the wheel here. We're just addressing the highest of the high points in things that matter to new council members. So first topic that we wanted to talk about is just very generally the form of government, the kind of government that you have here in the city of Victoria. The kind of government you have is you are a statutory city. A statutory city is to be contrasted with what is called a charter city. A charter, as I think you probably all know, is basically a mini constitution. It is a small, relative to the U.S. Constitution, document that sets up governance in a given Minnesota city, sets out the powers of that city, and those powers can exceed the powers that are granted to cities by statute, and otherwise sets out the way governance will be conducted in that particular city. There are about, and don't quote me exactly on this, there are about 200 or so, plus or minus, cities in Minnesota that are charter cities. They are like snowflakes. They are unique. Every charter is at least a little bit different. Some are a lot different, and so that is a different kind of city. You are a statutory city. Statutory city means, if you allow me to summarize it, that all of the powers of this city and all of the governance that you have, the governance structure that you have, are set out by state law. State law says the kind of government that you're going to have here in Victoria. That's a little bit of an overstatement. And it's an overstatement in this sense. It is true that your powers here as a city are limited to those granted to you by the legislature in statutes, but in a lot of cases, the statutes that grant you power are quite broad. And so the way you implement those powers, as an example, the legislature gives a city like this the power to adopt ordinances to advance the public health and welfare. Well, obviously, that's a very broad grant of authority. You might adopt an open burning ordinance or a no nuisance piles of waste in your yard ordinance or a dogs off leash ordinance. All of those would be exercises of your general welfare power. So it is true that you get your power from the legislature, but in some cases that power is quite broad, and the way you implement it varies from city to city. In a statutory city, what is, I think, one of the more important things to understand is that unlike charter cities where individual council members or the mayor might have special powers, as a general rule in statutory cities, each of you council members has one vote, and you don't get to act for the city. You can't unilaterally do things for or on behalf of the city. There are a couple of exceptions for the mayor. The most prominent exception is the one we just dealt with, quite candidly, and that is that the mayor is the parliamentarian. The mayor ultimately makes decisions with, if he wants it, advice from the city attorney, which I'm happy to give, but ultimately, Mayor, it is your call to make. I will say that the mayor makes those decisions in the first instance. If the mayor makes a parliamentary decision that someone disagrees with, you could object to it and put that question or that decision to a vote by the full body. So my rule of thumb about that most important, unique power of the mayor is this. You, Mayor, as acting as parliamentarian, recognize that as you recognize speakers, you control the flow of debate. You make rulings, which I just explained, subject to an appeal from other council members. And then lastly, you're in charge of decorum of the meeting. And typically, although this is not embodied in any law, typically because you are the parliamentarian, you try to be impartial in the way you act as parliamentarian. Clearly, there will be disagreements among council members. You will have a strong opinion one way or the other, and you should voice that opinion at the appropriate time. But as parliamentarian, typically we expect mayors to sort of even-handedly recognize members and even-handedly control debate. So that is statutory city. The next subset of that discussion is the particular type of statutory city that you are. The particular type of statutory city that you are is what's called an optional, if you can believe it, an optional Plan B statutory city. That is distinct from a standard plan statutory city and an optional Plan A statutory city. In an optional Plan B city, you have, Lori, you have a city manager. Oftentimes, this kind of government is called the council manager form of government. That is a significant difference from other statutory cities. There are, in fact, only 18, the League of Cities says, 18 cities in Minnesota that are a Plan B city manager form of government. And the reason that is different than other forms of government is that by statute, your city manager has powers, has authorities to do things. Most specifically, you see here on page 2 of the memo, the division of power between the full council and the city manager is that you, the council, make policy decisions. You exercise the broad legislative authority of the city. The city manager has power to run the city on a day-to-day basis. Is that a bright line? No, that is not a bright line. There is certainly room for debate there about whether a question, an issue, an action taken is a legislative policy decision or a day-to-day decision. I will tell you in my experience, the way that that is typically resolved, or what everyone is mindful of, is that the city manager, Lori, reports to you. Everyone else here at the city, all of the other employees, all of the other departments report to Lori. Lori has the power to hire and fire employees, has the power to run the departments here. She, though, reports to you. So obviously, when it comes to that line drawing question, often that falls to the city attorney, by the way, to resolve, Lori is going to be mindful of the fact that she reports to you all at the end of the day. Last point then about city manager form of government. I am a little bit different. The city attorney does not report in a city manager form of government to the city manager. I report to you. You have the power to hire and fire me and my firm. Lori does not have that power. And I don't like, candidly, the very popular these days comparison of local governments to private corporate bodies. But in this context, it actually does work. There are big differences between government and private businesses in a lot of other ways, but in this way, the city attorney is quite similar to a private general counsel in a corporation. I, like a private general counsel in a corporation, am responsible for the city as a municipal body, as a municipal corporate entity. I'm not the attorney for the council individually or, frankly, as a whole. I am the attorney for the decisions that you make as a council. And that's a fine distinction, but it's an important one. I'm also the attorney for decisions that Lori makes in her proper role. If she takes an action that is clearly a day-to-day decision, I am to further advance, defend that decision. I think that's it about city attorney. And then lastly, city boards and commissions. Another a little bit unique fact about Plan B cities like you are, in effect, city boards and commissions in a Plan B statutory city are always going to be advisory. There is no place for, in that statutory arrangement, for subsidiary bodies, subsidiary boards or commissions that have final decision-making authority. And that is true here in practice and in your code. All of your boards and commissions are advisory to you. There are two, is what came to mind to me. Please ask if you think there are others, but there are two exceptions to that. One exception that's important that Ben deals with quite a bit is that you have conveyed to your planning commission, as almost every city has, the power to hold public hearings. And that's an important power. Let's not skim over that. The power to hold a public hearing on a variance or on a conditional use permit or on a development application, that public hearing is the place where the facts or most of the facts get compiled. And so that's a very important function, but it does not involve making the final decision about the application or about what the facts are. Ultimately, that is for you to decide. The other example, and it's not a perfectly apt example, is that you have an EDA. You sit as the EDA. The EDA, though, technically is a separate municipal body. It is not really a subsidiary body to the city council. It was formed once by the city council, but it is now a separate living, breathing municipal entity that has its own powers that are separate from the city council. It's a distinction without a difference given that it's you all, but it is a meaningful legal distinction. I think I can stop there. That is sort of the form of government. If there are questions, I can move on if there aren't.
Please continue.
Next topic is the open meeting law. The open meeting law is hard to summarize quickly. I'm trying to move through this because you have other items. I'm going to take a little bit more time probably on this. The open meeting law, and now I'm quoting right from the open meeting law statute, applies to, quote, any committee, subcommittee, board, department, or commission of the city. I will tell you that those are nice terms, and they convey some meaning, but they're not defined in the statute. And that has been the source of some disagreement historically and in the pending litigation here. What the open meeting law requires is that any meeting of one of those committees, subcommittees, boards, departments, commissions of the city be open to the public, be properly noticed, be available for folks to come and attend. Unfortunately, again, the term meeting, what is a meeting of those various bodies, is not defined either. That, too, has been the source of confusion, litigation over the years, et cetera. What we can know, both from the litigation here and from litigation historically, is that a meeting does not include a chance meeting. That is an incidental meeting. If three of you run into each other at the grocery store, should there be one here soon, we hope, that's not a problem. We can talk about what produce we're buying. We can say hello. We can ask about the kids. We can't suddenly conduct a meeting that's going to discuss city council business, of course. So those kinds of chance meetings are not problematic. The sort of spin-off of that issue, though, is that meetings that are done serially do pose a problem. Can I cite you a particular case or a particular statute that refers to that? No, I cannot. That is suggested, though, in a lot of cases. A serial meeting, then, would be Council Member A talks to Council Member B about a given topic. Council Member B talks to Council Member C about that same topic. And through serial communications, in effect, a meeting about a topic is conducted. That is problematic, and we have encouraged and continue to encourage you to avoid that sort of communication. Use of email, another topic covered in the memo. Use of email is easy to cover. Email is just simply no different than any other communication, be it face-to-face, be it at a council meeting, be it on the telephone. Email is the same thing. It is communication that could, in appropriate circumstances, lead to an argument that a meeting has been conducted. Closed meetings, the inverse of the basic rule in Minnesota, the basic rule being that local government has to conduct itself in open. There are times when you are compelled to, required to close meetings, or times when you may close meetings. And I've set out in the memo kind of the most important examples of that. A less important, in fact, in my experience, it's never happened, but let's use it as an example of when you must close a meeting. A city council meeting would have to be closed in the event for some reason, and it's hard to conjure why this would happen, but if for some reason the city council had to discuss the identity of a victim of domestic abuse, the legislature has decided that that can only be discussed by this body or subsidiary bodies in a closed meeting. There are other examples that are sort of in that same category of clearly sensitive information that you must only discuss in closed session. The other examples that are set out are the most important, and those are essentially all may close the meeting situations. The first being certain kinds of personnel matters. In the event, for example, you are going to conduct a performance review of Lori. You would not, we wouldn't think, conduct performance reviews of other employees because, again, they report to Lori, not to you. But a performance review of Lori would be something that you'd be required to close unless Lori asked it to be open. There are other requirements. You must, before closing, explain what you're doing, what you're going to talk about in that closed meeting. It must be tape recorded, and that tape recording must be maintained for a period of time. Another example, an important example of when cities close meetings, and this city can close meetings, is issues related to property. One of the examples that's spelled out that may be less obvious to you is it says number 2 on page 4, confidential appraisal data. What is that talking about? That is something that has mattered here. In the unhappy event that this city needs to condemn property, acquire property by eminent domain, you may need to get an appraisal done. That appraisal is confidential until that litigation is completed, and you're entitled to talk about the appraisal and talk about its impact on the litigation in a closed session. Another example is if you are developing an offer to buy real property, buy real estate, or you are considering an offer to sell real estate that's owned by the city, you can close the meeting. You must announce in advance the property you're talking about, and again, you must tape record and maintain the tape recording of that meeting for a period of time. Attorney-client privilege matters. This has been historically an area of contention. Public or the press have been concerned about cities closing meetings because of attorney-client privilege or claimed attorney-client privilege. As a result of that, there's been litigation, and this privilege has been narrowed. So the ability of a city to close meetings to talk to the lawyer has been narrowed. I will give you the kind of the best examples where cities can, where we could, in theory, close a meeting to talk attorney-client privilege things. The best examples are, one, obviously pending litigation where the city is a party to that litigation. In those kind of cases where there is pending litigation with the city as a party, you may need to talk to me about what you want to do next in that litigation. So that's a clear example. Another example, it's a little bit more nuanced, but it's important for you to understand, is the courts have looked with a jaundiced eye at cities that have said, we need to close a meeting to talk about things we've already done. We've taken actions in the past, and now we need legal advice about the implications of those actions we took before. Courts have said, well, wait a minute now, those actions are done. If the lawyer needs to tell you about the implications, there isn't a great compelling reason that the public shouldn't hear about that. The inverse of that is that when you have not yet taken an action but are considering it, courts are much more likely to allow you to ask the attorney in private, what are the possible ramifications if we do X, Y, or Z? So think about whether we're talking about something in the past or something moving forward, should we ever face the question of closing a meeting for attorney-client privilege. Security matters doesn't come up much, although it may come up more as we've had more need for it. The example of security matters is I've got a couple of cities that have talked about installing bulletproof glass in various parts of the city hall that the public should not know about, since it is to protect those employees behind that glass. Moving on then, away from the issue of closed meetings, notice of meetings. The open meeting law tells us how to give and when to give notice of meetings. One of the items on the agenda tonight is setting a regular meeting schedule. Have we just done that, or is
We
that?
have.
We've just done that. So the importance about setting a regular meeting agenda, a schedule of meetings, is that should you do that, as you have done, and then put that on file with the city available to folks that want to see it, you then don't have to take other special steps to give notices of your meetings. You don't have to post notice of your meeting. You don't have to take other steps. So it's important that we've done that. We will, though, occasionally have either special meetings or workshops or other meetings that are outside of your regular meetings. In those cases, we have to post notice. Here is what is important about that. The posting of the notice is not difficult and something that we can handle. What's important about it, though, is that in posting that notice, we must identify what the meeting is going to be about, the purpose of the meeting, and because it has to be posted 3 days in advance, we can't then change what we're going to talk about once we get to the meeting. Of course, at your regular meetings, you adopt an agenda, which could be modified at the beginning of the meeting. We can't do that with special meetings. We are restricted in what we can talk about at those meetings.
Excuse me, Bob.
Yes?
Who's responsible for posting those notices? Is it the mayor?
Yeah, mayor and council, in practice, the way it's been done here is that the staff is taking care of that.
Thank you.
I think Lori would speak to that. I think that's the plan going forward.
Correct.
What, on that same kind of vein, what does posting it, what constitutes posting it? Obviously, with 3 days' notice, it's not a legal notice in the newspaper of record. So what constitutes an acceptable posting?
So posting of the notice, there maybe should be sort of size requirements on the notice. The size of the notice, they're typically posted on regular old 8.5 by 11. But they are posted either at the officially identified bulletin board that some cities have or on the door to the meeting room, the regular meeting room. I guess I'm not sure if the practice here has been one or both of those places, but those are the permissible places to post notice of special meetings.
We use the official bulletin board, which is located in the lobby of City Hall to the right of our main desk.
Thank you.
Do we post those on the website?
We do. That's not required in our city code, but that has been our practice.
Thank you.
I'm looking at page 5, if you're following along at home. This is a requirement in the open meeting law that votes of the council be recorded. I will just tell you as an aside, there are different laws that require us to keep minutes. They don't require very detailed minutes, but there are other laws that require us to keep minutes, and so this requirement about keeping a journal of votes has really been subsumed by the requirement to have minutes. And of course, you do have minutes, and your minutes have historically, even in the time that I've been here, changed from verbatim or virtually verbatim to somewhat less verbatim minutes, and that's perfectly legal. Access to meeting materials, this is important. This goes to a topic later on the agenda. Let me just highlight that. I don't want to step on toes on that agenda item coming up later, but access to meeting materials. The open meeting law requires that any materials that you have in front of you that are part of your agenda packet be available in the room, in the meeting hall, to the public. Folks that want to take a look at what you see need to have it available to them in the room. That is important as you think about the way you're going to set agendas, because, of course, if you have sort of unlimited ability to add to or change agendas, it's going to be at least difficult, I'm not going to say impossible, but difficult to then distribute materials to all of you and to the public should you be adding agenda items late. Some cities, and I think Lori and staff's going to talk about this when we get to the item, some cities adopt internal rules that simply prevent that. If something hasn't been provided to the staff and to the council by X date prior to the council meeting, it can't be considered. You can impose that kind of a regulation on yourself. It's not required, though, by state law, but it does make a little bit of sense to avoid the problem of having to have it available in the room.
On a practical standpoint for this item, we do keep a white binder at the sign-in table that contains a complete paper copy of the packet. Anyone who's here is welcome to grab that binder and look through it. Obviously, there's just one copy for everyone here, but the full council agendas and packets are posted on our website /agendas. So all of the materials that the council has to review are also available to the public.
So I've got a question for you. Like tonight, if I've got materials that may or may not come up as part of an item that's on the agenda that the council's going to discuss, do I need to provide those materials ahead of time, or since they're reference materials for me, and they may, as the letter from Tom Grufhofer and Julia Ring came up tonight, so the question is, do I need to provide those ahead of time, or do I have those as references? How does that work?
Yeah, so Mayor and Council, if I understand your question, so to the extent you have materials that are going to be helpful to you, we'll talk in a little bit about quasi-judicial decisions, and so bear in mind that I'm going to have a caveat about what I'm about to say when we get there. But putting that aside, there is not a requirement that you share with the public or put in the public binder materials that are not available to the entire council that relate to a council item that all council members are going to see. In other words, if it's just there as a crib note for you or help for you, that doesn't have to be distributed. If it's going to be distributed to all of the council members, electronically or otherwise, it needs to be made available in the meeting room to the public. Again, exception of the quasi-judicial stuff we'll talk about in a bit. The other exception is that if something is clearly non-public under the Data Practices Act, we're going to get to that next, and can't be shared with the public, that's an exception to having to make it available in the meeting room.
Thank you.
I have a question with respect to the official posting or noticing of a meeting. If we want to make it part of our city code to post it on the website, which I'd be in favor of if anybody's interested, how do we go about that? I mean, do we just take a motion? Does it need to be an agenda item in a future meeting? How do we go about doing that?
I would recommend that it be a future agenda item, and I believe we make changes to our code always through ordinance. So it would be,
So 4/5 vote and public hearing and.
Yeah, Mayor and Council, that kind of thing would not require a 4/5 vote, but yes, you would do it via ordinance. I mean, I will say we're a little afield, but it's a good topic. I will say at the time that this comes up, I'm always a little leery of imposing rules on yourself that if you trip over them would invalidate the action you've taken. So if you have failed, for example, to put a notice on your website inadvertently and then have that meeting, I'm a little leery always about the consequence of that. So I would want to be careful about the way you craft that. But certainly you could impose a rule on yourself that you must post all notices on your website. Certainly you could do that.
So quick question specific to this. If we make a policy, if the council were to make a policy that says we're going to post all meetings versus an ordinance, what is the significance difference between just a policy versus an ordinance?
I think a violation of a council policy would be a discussion that you would have with your staff, me, in terms of performance, where a violation of your ordinance is something that someone could take you up in court on. And I would just interject that our policy is to use the website extensively. There are several different areas of the website that we utilize to publicize public meetings.
So the standard practice is to put everything on the web, and have we had any challenges remembering to do that or to do that reliably?
And not that I have been made aware of or would come to mind.
Thank you.
Website's a very convenient place for us to promote meetings and events.
Are we doing additional postings besides the website?
We do have social media accounts, Facebook and Twitter, that we have used depending on the content of the meeting and the type of audience that we're trying to reach. And then we have some requirements for U.S. mail notifications for certain types of meetings and decisions and public hearings. And then we have used U.S. mail for things that are not legally required. We have the Victoria Spirit that's published quarterly that we might put things in. Trying to think if there are other outlets. In general, I would say that our goal is to get as many people that need to be or want to be informed on an issue to attend the meetings that we're holding, and so we use the outlets that seem appropriate to do that.
One final point. Would you let everybody know, I don't think everybody in Victoria knows that they can sign up on the email list and get email notifications
One of my
anytime they want?
favorite things to promote. Thank you. If you go to our homepage on the right-hand side, there is a spot that says Notify Me. If you click on that, you can enter in your email address, and we have, I think Ben's going to do it real quick, which is great. We have probably 10 or 15 different email lists that you can subscribe to. A couple of more popular ones would be Newsflash, which is the items that we post on our homepage. If you signed up for that, you could expect to get probably no more than 5 emails a week, sometimes less. You can sign up for an email to be alerted when we publish an agenda for any city council or committee. Those are all separate items you'll see under Agenda Center. And then the community calendar and the government calendar would alert you when we set the date of a meeting. So as an example, if you're really interested in following the activities of the Park and Rec Committee, you could sign up for the government calendar. That would give you an alert when any special meetings are scheduled. And then you could go down to the Agenda Center and sign up for the Park and Recreation Committee. And once the agenda for that meeting was published, you would get the agenda and a link to the full packet. We do some special projects. Ben, if you don't mind scrolling up for me. You can see Marsh Lake Road is a project that's under consideration, and we've got an email list for that. The 2017 street improvement project. And we continually add to this list and change it as there are relevant topics before the city. So it's a great tool. I know our email boxes are all really full, but it's a nice way to just scan and keep up with what's going on with the city.
Thank you, Lori.
Thank you.
Next topic on the next item up for bid is interactive television. I don't have much to say about that. Quite candidly, I've had a lot of city clients that have wanted to do this, that is to have council meetings where somebody isn't present but is on Skype or is on the equivalent to Skype, whatever it's called. And it's very difficult to pull it off. So it is theoretically possible to do that. If anyone is on vacation and interested, we can try it, but it's difficult. You both at the other end at your vacation place have to be able to see everybody in the room and hear everything that's being said, not just on the council, and vice versa. Whatever room you're in, the folks in the room have to see the entire room that you're in and hear everything. And so just as a practical matter, it's quite difficult to pull that off, but it is theoretically a possibility. And the last topic about open meeting law is remedies for alleged or actual violations. And they are that in the event of a violation that's adjudicated, there can be a civil penalty of up to $300 imposed on each official that is found to have violated the open meeting law for each violation. And in the event there are 3 separate adjudicated violations, that official is removed or will be removed from office. That is a shall remove. The court doesn't have any discretion in that matter. And then lastly, and it's not insignificant, is that in the event a plaintiff, a citizen, or another person alleges an open meeting law violation and prevails, it is possible to seek costs and disbursements and attorney's fees up to $13,000, which would be paid by the city. And so the city has certainly an interest, a large interest in addressing and avoiding those kind of problems. I will say, and it's the last note here, and you can read it for yourselves. I won't spend a great deal of time on it about the pending litigation. Everything, and I think almost literally everything other than the interactive television, everything that I've just said about the open meeting law was raised in the pending litigation and was in one way or another resolved in that litigation. As I think everybody in the room knows, that litigation is on appeal, and so I guess I would anticipate there's going to be some further clarification and probably some tweaking of the advice and the information that I've provided to you from the Court of Appeals and from any other courts that ever might hear about this kind of a matter. So we'll get back to you as that occurs and as additional information can be provided. Here is the takeaway, though, and this I do want to mention. This is on starting on the end of page 5 and on to page 6. Our advice, given the pending litigation, and given the potential for changes and where we are, given the Carver County Court decision, is we make 3 recommendations to you. The first is that I told you at the outset that what a committee, board, subcommittee, that statutory phrase, that's not defined. There are competing court decisions about exactly how broad that concept is. In other words, what is a city committee? Show me what a city committee is and what it isn't. Our advice to you is just not to get into that discussion or debate at this point. I would just treat any body, any group that is sanctioned by, created by, recognized in some formal way by the city council as being subject to the open meeting law. I think that has been the current staff practice and one we would intend to continue. I will tell you that that is an overreach. That is overly defensive on our part. There is no way that some group that this city council recognizes or could recognize is really subject to the open meeting law. Here's the example I thought of before the meeting. You may have a neighborhood group that just has informally been meeting about a drainage problem in a given neighborhood. If that group were to come forward to you and say, we've got a problem, we want you to do something about it, and you in some way blessed that group to give you further information down the road, you have not converted that group really into a body subject to the open meeting law. Think about the remedy. The remedy if that group were to violate the open meeting law. A judge would order, in theory, someone to no longer be part of the neighborhood group. It's not workable. It's not practical. And so I'm overstating the rule, but I think it's safest if this council is going to recognize and take information from in some formal way any groups that we ought to seek to treat them as being subject to the open meeting law. What arises out of that, the second bit of advice, is that any groups that you have blessed, sanctioned, created, established, will have to, when they get together, a quorum or more of them, will have to comply. They will have to allow others to be at that meeting. They'll have to have the meeting at a place where others can be, and they'll have to post notice of that meeting. That's something, again, I think the staff intends to help with to the extent possible, but that is the recommendation. And then lastly, I already emphasized it earlier, we very much want to, because the parameters of the problem, the serial meeting problem, are not perfectly delineated, we want to avoid that problem. And so we would encourage council members to only discuss city council business here at city council meetings to the extent humanly possible, and if you must communicate between yourselves, to involve or direct those communications through the city manager so that that can be monitored and she can help avoid that problem. So I don't think that's perfect advice. I think that that is, again, overly broad advice, and it may be pared back when we get further clarification from this court case, but that is the safest way to proceed, and that has been the way we are attempting to proceed and have been for some time. That is the end of topic 2. Moving to topic 3, the Data Practices Act, the Data Practices Law is how it's titled. It's really the Data Practices Act. I am going to actually successfully summarize this one a little bit more. The reason I'm going to do that is this. Here are the basics of the Data Practices Act. All government data, which is in effect any data, electronic, written, or other tangible information that's in the city's hands, in the government's hands, must be made available unless a statute says it should not be made available. So all data, whatever form it takes, needs to be made available if somebody asks for it. There are then 17, I didn't count them, but a lot of pages of statutes setting out every single exception to that general rule I just stated. There are a lot of examples of private. A lot of private data relates to employees, information that the city acquires about its employees that should not be made publicly available. Confidential data, which is an even higher classification of non-publicness or not public at all, which means no one gets to see it, not even the government in certain circumstances. What are the requirements of this fairly complicated regime of everything is public except the incredibly long list of exceptions to that rule? The requirements of that regime are, first of all, that the city must allow a person to see, a person that requests to see, must allow that person to see the data and, if requested, make copies of that data. And right on the flip side of that, the city is obligated to not allow that person to see anything they shouldn't see. So anything that is confidential, non-public, privileged, they must not see. And there are consequences to the city if we make a mistake about that. There are consequences if we don't allow folks to see what they do get to see, and consequences if we allow them to see things that they are not permitted to see. And then lastly, as a result of what I just said, the city is by law required to appoint a responsible authority. We've appointed the city clerk, a responsible authority, and a compliance official, an official that looks over the responsible authority and makes sure we are complying with the obligation to make available and not make available in accordance with the law. The reason that I don't want to continue on with more of this fascinating topic is because I am not kidding you when I tell you there are 17 or so, whatever the number is, many pages of exceptions to the general rule, many different classifications for different kinds of data. There are, as some of you would know, there is a division of state government called IPAD, the Information Policy Analysis Division, that issues opinions about what has to be provided and what can't be provided. There are hundreds of those opinions. There is a lot of litigation, and so trying to summarize in before next week, all of the classifications and all of the different kinds of data would really be difficult, and it falls to, in this case, very clearly by statute, your responsible authority to make those distinctions. The way it works in practice, if you sort of care to hear about how it works in practice, is a request is received, you have a form for making a request. Many cities do have a form for making requests that helps everybody understands exactly what's being asked for. That form goes to the responsible authority. She will, as needed, and it's not infrequent that she needs legal assistance, she will ask me. I will tell you, because this is such a complicated area, there is a person in my firm who is just our one Data Practices Act expert. It would take a person a fair amount of time as an attorney to become expert in this, and so we have done that. We've got a person who does that, and so if I can't answer the question, pass it off to somebody who is our expert. Lawyers can't be called experts, but our most experienced person in Data Practices Act issues.
Bob, a quick question. The question of what, the definition of data is the only thing that's sort of rolling around in my head on this. It's, generally speaking, we are consumers of the data. It comes to us from the staff, and so we're not, I suppose there are exceptions where we may bring information in, but generally we're the consumers of it, so it's already, by definition, in the city's control. But what about any notes or any thoughts we, jot down as we're going through the discussion and deliberations for our own kind of, thought process? Is that considered government data at that point, and should it be submitted for archiving at the end of the meetings?
Yeah. Mayor and council member, I'll give you the candid and unsatisfactory answer, and that has not been resolved. It's not resolved by the statute, and that question has not squarely been resolved in any iPad or any court case. I think that it's going to have to be subject to a smell test. In the event you are on a committee and you are taking voluminous notes that become relevant to the committee, clearly those notes would become government data at that point. If they are truly solely for your personal use and are not distributed or shared with or even discussed with others, I would have a hard time telling you must turn in your homework at the end of deliberation or a committee process and make that data into government data. The reality is, and I think you all appreciate that this is a fairly significant issue right now in the state of Minnesota. It's gotten a fair amount of press in the Strib and in other places. Hennepin County, as an example, has a court case that was just argued this week at the Minnesota Supreme Court about access to data. As a result of that pending litigation, Hennepin County Sheriff's Office has now got a new retention policy, which is a different question than the Data Practices Act, so bear with me. Retention policies are the policy a city would have or a county would have for how long you must retain documents, information. You may get rid of things as long as it's in accordance with a policy. Hennepin County, because of this court case, has changed its policy to retaining emails for only 30 days. And the point they make, and it's a fair point, is that there are literally now millions in Hennepin County of emails, and it's simply infeasible to retain all of the emails that are generated by the Hennepin County Sheriff's Department. There has to be some system for moving out and taking in new emails. So I have a feeling that your question, which is a totally fair question, may at some point get some legislative attention. What is data? Where is that line more brightly drawn? It's a fair question. I can't, other than that smell test that I described, I'm hesitant to tell you throw it away or turn it in to Lori. I think we'd have to talk about it and what it is.
Fair enough. Thank you.
In broad terms, if I could add, there are a number of items that the records retention policies would not speak to. If the city has them in our possession, we would provide them. So it's often a distinction, a couple of distinctions that have to be made. Are they things that we are required to save? And then if we have saved them, even if we don't need them, then they would be available.
Mayor, Council, I'm on page 9. We are starting to run downhill now here. We're on to the gift law. The gift law was a hot topic 20 years ago or so. It has become less, you don't see articles in the Strib so much about that, other than, of course, the most prominent example of it coming up, which is the box seats at the new Viking Stadium. The gift law, if you'd allow me to summarize a little bit, says that you, as elected officials, with power to make decisions can't receive gifts from people that have an interest before you. Interested persons, persons that have a direct financial interest in some matter that has or will come before you as a city council. There are, as it seems like on every topic we talked about here, exceptions to that rule that you as individual council members can't receive gifts from anybody that has an interest before the city. The most prominent exceptions are campaign contributions. You have all gotten out a run for election and gone through the fun of that, and part of that is collecting campaign contributions. Those are not gifts that are unlawful under the gift law. Another example that matters here in Victoria is that local governments can give mementos of insignificant value, plaques, mementos, other things to recognize service to the city. You can receive gifts that cost less than $5. I'm not sure if $5 remains the relevant number in reality today, but that's what the statute provides. And then lastly, to the extent you should give a speech, and again, some of you may be asked to give speeches in your capacity as Victoria mayor or council members, you can receive food or beverages at that speech because goodness knows it's going to drag on for a long time and you got to eat. So those are exceptions to the gift law. There are some other less important exceptions as well. I guess the last point on page 11 is that there is no social exception. So in the event you attend or your kid is getting married and somebody who has a matter before the city council comes and gives you a gift, there is no social exception. If that person has an issue before the city council pending or coming, there isn't a I'm not giving it because of that, I'm giving it because of that exception. So be mindful of that. Next topic with 2 to go is conflicts of interest. Conflict of interest, again, has been summarized. There is, as with all these topics, a fair amount of law and court decisions behind these topics. The summary version that you have in front of you is that you as city council members must disclose and then cannot participate in matters before the city council in which you have a personal financial interest. Really, if I were to have broken this down further, and let's do it now, really that personal financial interest is really divided into 2 categories. One is contractual conflicts. That is where you would propose to make a contract with the city. You would propose to sell a service to the city under a contract, to buy something from the city under a contract. You as individual council members have a conflict in the event you're entering into a transaction with the city. I think that is probably self-evident, but that is one part of conflict interest law. You can't do that except for a very limited exception that's discussed in the memo. The other kind of conflict, which is frankly broader and somewhat more important, is what I've just said, which is that if you have a unique, usually financial, but any sort of unique interest in a matter that comes before the city council, that can pose a conflict of interest. This is a little bit more nebulous because this kind of conflict, the non-contractual, non-transaction-based conflict, is born out of a whole bunch of court cases. It is a common law, in other words, rule of conflict of interest. The rule, though, again, is that if you have a unique, clearly unique interest from other folks in the city about a matter that comes forward, that is something that should be disclosed, talked to with me if you feel comfortable doing that, and something that you're going to need to consider not participating and voting on. The classic example, and I've given you a whole bunch of examples where a conflict has been found or a conflict hasn't been found. The classic example, and it has mattered here in Victoria in the past, is in the event the city does a public project. We're going to build a new road, and there is exactly one residence on that road, and that's the sole residence that's going to get specially assessed for that new road, and that happens to be a council member's home. That sure looks an awful lot like an issue where that council member has a unique financial and other interest in that project, and we're going to have to think hard about not participating on that item. If, though, you're in a neighborhood of 200 people that have roads that are being improved, and it is part of a generally followed policy of upgrading roads in the city of Victoria over time, and council members have a home in that area and are going to be specially assessed, the courts have found that that would not be a sufficient unique interest. I've actually talked to the city council in the past, prior council, about that issue on a recent project where you have what you have, which is a systematic upgrading of streets, and you have a relatively large base of people that are going to be specially assessed. Really, your impact, your interest in special assessment is no different than everybody in the city. everybody eventually in the city is going to get to pay a special assessment. If you continue a special assessments to fund roads, everyone is going to be in that same spot, and so your interest is not unique. That's the kind of analysis that we do. You see that the court's listing of issues that we're supposed to consider. That's under A. The nature of the decision being made, I think that's what I've just been talking about. The nature of the financial interest, that's what I've just been talking about. The number of interested officials making the decision. The reason in the court case where these factors came out of, that was important, was there were so many, it was a town board, 3 town board members, 2 of the 3 were interested in the decision, and so taking them out of the ability to vote left the decision to one person, which was not the favored result. The need for the interested official to make the decision, that's what I've just been talking about. And then lastly, other means available to review the decision to ensure that officials don't act in their own interest. These are all different ways of saying if it's too much about you and your interests and not enough about the city's general interests, that may well be a conflict that you should consider and consult with legal counsel about. Anything else about conflict of interest? Conflict of interest, I guess the last thing, what's the consequence? It's a dual consequence. It's our issue, my issue as the attorney for the city as a corporate body, and it's your issue as council members. It's my issue because in the event we take action here where somebody has a conflict, that action could be invalidated. That action may be void because of the conflict of a member. It's your issue, too, because in appropriate circumstances, I got to tell you the truth, I've not seen this kind of prosecution before, but in the appropriate circumstance, it is a misdemeanor. It is a crime to participate as a city council member in a matter in which you have a conflict of interest. Related topic, incompatible offices, which is the next topic, is a very closely related concept. It really rarely comes up here. Let me just give you the concept and let me know if you have questions about it. The idea of incompatible offices is that you as council members cannot hold other public offices that are incompatible with your role as city council member. The most obvious example would be a county commissioner in the same county where you're on a city council. And it would have to be the same county, I think. So because those are in the direct line of command, the county and the city county may give direction to the city may give direction to the county on certain matters. Because one is over the other, those are incompatible offices. There are a number of other examples. I actually had in a different city this example, the example where a council member was invited to be the EDA director, a staff person in a neighboring city. The question that was then posed was, wait a minute, as a council member, you have a fiduciary duty to further our city's interest. You have a duty to help us develop businesses here. If your job next door is to develop business next door, aren't there going to be conflicts between your job and your fiduciary duty on this city council? That's another example of incompatible offices. If that comes up, please let's talk about it.
So Bob, is it implied or stated specifically that both offices are public offices, or is it even a private office, your day job, so to speak?
Mayor and council members, it is implied that it is a public office that we're talking about. But let me be clear, because you have a question about it. It need not only be an elective office. There have been a number of attorney general's opinions dealing with sheriffs or city police chiefs in non-elective positions. Sheriffs haven't always been elected. And a finding that in the event the sheriff position is in the same jurisdiction where the person is serving as an elected official, those positions are incompatible for reasons including as a sheriff or a head of a department like that, you'll be seeking funds from the body on which you sit as a elected official. That is but one example. There are other examples of where that incompatibility may come up. So no, it's not limited only to elective office, but it is public office of some kind.
Thank you.
Liability matters, important for you to understand as council members. There are essentially 2 areas, and we've talked about one in the past here, where the city would be obligated to defend and indemnify you. Defend means, of course, get for you, provide to you, or pay for an attorney for you. Indemnify means essentially cover costs that you are compelled to pay or bear as a result of a claim against you. two examples. One is that state law makes clear that a public body may pay costs, attorney's fees, et cetera, for a member accused of an open meeting law violation. And then state law, on the other hand, mandates that a municipality defend and indemnify a public official for an alleged malperformance of duties. The issue with that is whether or not the action that's been alleged is so far afield from appropriate duties, whether that indemnification and duty to defend applies or not. But generally speaking, what we're talking about there is you've caused a personal injury somehow. You're driving to a council meeting and hit someone in the course of your duties as a council member to get to a council meeting. The city would have to defend you unless you were acting so far outside of the scope of that obligation to get to a meeting that the city would not have that obligation. Then lastly, the exciting added topic, quasi-judicial decisions. The concept here, this has become a newer important topic in recent years. We had a fairly prominent case that I've mentioned here in the last paragraph of this added information arising out of the city of Minneapolis, where, let me back up. Quasi-judicial decisions are decisions that you have made, this council has made in the past and will make in the future. The examples of that are where you are acting as, in effect, a court. You are hearing about facts that may be disputed by, for example, competing landowners, and deciding on whether to issue, as examples, a variance, a conditional use permit, or other similar, typically land use approvals. In those cases, you are acting like a judge. You are weighing facts and deciding how those facts line up with a legal standard, usually a legal standard that's in your city code, for whether to grant or not grant the requested application. In those cases, the courts have found that you should remain, as a judge, to some extent, neutral. I say to some extent because the reality is you are not judges. You don't wear black robes. You are elected officials, and you're expected to know what's going on in your community and communicate with people. That's not prohibited, but you are on a quasi-judicial decision, a pending conditional use permit application. You are expected to keep some degree of impartiality and distance from the competing interests. That's important to understand because, of course, you may become aware of something that has not yet been applied for, something that is coming down the road. What happened in the city of Minneapolis case was just that. An application was coming before the city. It had not yet been teed up in front of the city, and one of the council members became an advocate on one side or the other for or against that application. That council member then ended up voting on the matter, and the court, the unsuccessful applicant sued. And because that council member had really taken an advocacy role, had picked sides before voting, the decision was struck, and the decision had to go back to the city council without that council member participating. So, quasi-judicial decisions are special. When you're acting as a judge, we need you to maintain some impartiality and some distance from the various parties that are going to be bringing that before you.
Bob, can you talk to precedents with respect to quasi-judicial? I can't even say it. Section 8?
Section 8. Sorry, Councilmember, precedents?
Precedents?
Well, the most prominent precedent, I think, is the city of Minneapolis case that I'm talking about.
No, I mean in terms of the decisions based upon precedents, things that the council has done in the past, and if you go against those things that the council has done.
Oh,
in the
I
past.
see. Yes, I can speak to that. I'm not sure what you're thinking about. I guess when I think about precedents, I have said before here and at other client cities that there is a need for you to maintain some cohesiveness in your decision making. That's important as a practical matter. The folks that live here and bring applications before you need to have a sense for what the city is doing and the direction of the city. That said, legally, there isn't really the concept of a precedent in a conditional use permit or in a variance or in a name another quasi-judicial decision. And the reason is because the facts are never going to be exactly the same. The facts are always going to be different. They may be greatly different or they may be a little bit different. But regardless, you never have the exact same application before you, and there are always reasons that you may change your mind. You are entitled to do that even when you're acting as a judge. In fact, judges do that, of course, right? Judges decide cases differently depending on the facts. So, no, you're not bound if you granted a CUP to applicant A 2 years ago and applicant B comes forward tomorrow and the facts seem similar but not exactly the same. You're not compelled to grant that CUP again.
If I can add, I think what staff tries to do to be helpful in clarifying these issues is that staff reports include specific reasons that are legally permissible that you would use to approve or deny an application. And we encourage you to rely on those as you discuss an application. And if you are bringing something forward that's not included in a staff report, just that it be very specific and fact-based and not vague or based on personal opinion, to try to link that, again, with fact or city code, things that can be pointed to should it come to that.
Mayor, I'm going to take a breath now.
Excuse me. Thank you, Bob. Appreciate you going through that. Next item on the agenda is the committee appointments and discussion, basically 7B here. So I don't get stuck into a parliamentary procedure quandrum here or quagmire. What is the proper procedure to go ahead and initiate a discussion on this topic?
Mayor, is that a question to me?
Yes.
Yeah, okay.
Thank you.
I think you would ask staff typically to make a presentation on what's before you and then start debate.
All right. Thank you, Lori.
Thank you, Mayor. The item before you tonight is something that is typically considered at our first meeting in January, and that would be the appointment or assignment of city council representatives to our various committees. And also at this time, we would typically run through a list of the appointments that are coming up for expiration at the end of March and talk about our process for advertising and making appointments to those positions coming up over the next couple of months. As you can see in the outlined in the memo, we have a Finance Committee, a Park and Rec Committee, the Planning Commission, and the Victoria for a Lifetime Committee. In terms of council assignments, typically one member of the City Council and the mayor have served on the Finance Committee. Under the normal rotation that had been in place for the last several years, Councilmember Gregory would be assigned to the Finance Committee. Councilmember Vogt has also expressed an interest in serving on the Finance Committee. The Park and Recreation Committee, under the normal rotation, and this will be just the opposite, Councilmember Vogt would be assigned to the Park and Recreation Committee, but I understand Councilmember Gregory has an interest in serving on the Park and Rec Committee, so I would submit to the council that it might be possible to sort of flip-flop those assignments within the rotation if that interests you. The Planning Commission typically does not have a council member that would be assigned to the Planning Commission. It works in the inverse by practice, that the members of the Planning Commission rotate attending the council meeting and act as the liaison in that manner. The Victoria for a Lifetime Committee does not have a requirement for a city council representative. Mayor Tom O'Connor had served on that committee in the past out of a personal interest, but there is no requirement for a council representative. We also have two, what I would call subcommittees or task force. We have the Pool Committee that reports to the Park and Recreation Committee and then to the City Council from there. There is no City Council representative to that committee at this time. And we also have a Water Task Force that was appointed in 2016. The council representatives to that are Tom Striegel and Tom Vogt. And both of those were intended to be committees and appointments that would go for the duration of the project or the subject matter, not to be appointed annually unless the council wanted to talk about doing something differently. I did outline in the memo, but I will allow Mayor Funk to cover some ideas that he has to change just a little bit how we might approach the committee structure. Before I turn it back over to you, I'll just summarize in saying that what I am looking for tonight would be assignments to the City Council representatives for the Finance Committee, the Park and Recreation Committee, and if you chose to do so, the Victoria for a Lifetime Committee. There are a couple of citizen appointments for the Victoria for a Lifetime Committee that I can go over if you get to that point. And then also, if we would get to this point, just to have the council talk a little bit about advertising the openings for these positions over the next couple of months and the process for making citizen appointments.
Question for Lori and the attorney. Is having a husband and wife team serve on the same committee a potential conflict of interest?
I'll turn.
Mine?
Go ahead.
Mayor, council, no, I don't think
That's
so.
all I need to know. Thank you.
Okay. At this point, I'd like to start the discussion. If there's no other comments from the council, I'd like about 5 minutes to walk through some of the issues that I see for the city of Victoria. So is there any quick opening statements, or should I just go into it? Council?
Right ahead.
All right, so I'm going to bring up the open meeting lawsuit, not in an effort to rehash that or relive that. I'm bringing it up simply because of the fact that I want the residents of Victoria who have not heard the story and have probably not read the judgment to understand that what I'm going to propose to the council as far as reforms and how we handle our committees is based on lessons learned, if you will, that came out of that lawsuit. So very briefly, there was a real estate committee that was formed in June of 2011 in a closed session by the council. That committee was later found to have violated the open meeting law for a number of reasons.
Point of order.
Go ahead.
This is pending litigation. This is not settled law, and to present this as a fact is misleading.
Mr. Bob, given the fact that the district court has rendered a
District
judgment.
court is not, the district court, and you, sir, have appealed it. And so it is pending litigation, and we are waiting the outcome of that. To discuss it here as settled law is incorrect. And according to our rules, I will have to get up and leave if you're going to use this as a basis for formulating a decision. It is incorrect, and it is a conflict of interest because you are the lead litigator in that.
So we won't refer to the judge's order. We'll just simply say that that committee existed. There were questions about it. Joe Pavelko, the council member back in 2013 in July, least experienced council member, raised questions
Point
about...
of order. The rec was not found to violate the open meeting law. There was not a decision made in that regard. And again, I'm going to request that this line of discussion cease because it is incorrect and it is leading both the council and the citizens down a path of opinion.
Bob, is it fair to talk about the judge's decision issued on 31 March of 2016?
Mayor and council, I guess, I'm not sure if I understand how the point of order has been stated, council member, but...
My concern is it's being presented as settled law and fact, and it is not settled law and fact. It is opinion at this point in time that is under review, under appeal by this gentleman here, and to present it any other way is a fallacy.
I'm not...
And if we're going to go down this path, a point of order, we have to stop this discussion right now. This is not right.
Is there a conflict of interest here?
Yes.
That's my question to our attorney.
Well, so Mayor and council, as to the point of order, I mean, I guess I don't know that speaking about facts that are incorrect is out of order. You're all entitled to debate based on the facts as you understand them, and then you're entitled to correct one another to the extent you disagree. So I don't know that I see that as a point of order issue, one. Two, your question, a conflict of interest. The matter that's before the body that you're debating right now, discussing, is appointments to a committee. I'm happy to hear how pending litigation in which some of you are participants would present a conflict for choosing committee members. We're not talking about, I don't see it, but I'm happy to hear.
If we want to talk about appointing members to a committee, which is what I thought the agenda topic was, I'm perfectly fine with that. But when we start to bring in other topics related to that, that's where I have an issue.
Yeah, where I was going with this is I want to propose reforms, and I want the citizens of Victoria to understand the basis why I'm proposing reforms. And those reforms are based on what happened during that lawsuit. So,
For the record, I oppose this. I disagree with it. If we want to talk about appointing committee members and changes that you would like to make, if you are limiting your discussion to that, I'm perfectly fine with it. But when you start to bring in discussions and cases that are still under litigation, that's where I draw the line.
It's also incorrect to characterize the ad hoc group that was reviewing real estate as a committee. It was not a committee that was formed as a committee, and I think that's clear to everybody who's familiar with the details. So I think it's a disservice to use that as the basis. If you want to talk about things you want to do, that's great. But
well, I stand by the judge's order issued, but we'll go at this a different way because I don't want to relitigate this issue. Instead of that,
that's my point. Let's not relitigate it. Thank you.
Right. I encourage everybody to read the judge's order that was issued on 31 March 2016. You'll see a lot of information in there about committees, and we'll leave it at that. So here's what I'm proposing, though. I believe we have serious problems with transparency. When I launched my campaign, I promised the residents of Victoria that I would focus on transparency and meaningful public input so that the residents of Victoria could understand what was going on. The reforms I'm going to talk about tonight are really driving at the heart of that, things that I believe have not been done well, and these issues begin with, and as a first step only, is how these committees work within the city of Victoria. Therefore, what I want to do is propose either an ordinance or a policy that gets into and specifically does 4 key points, and we can discuss some of the details. First, I think the citizen representatives that are appointed on any official committee of the City of Victoria should be based on a precinct distribution across the city. The reasoning behind that, in my point of view, is so we don't have concentrations in certain areas, but we get all of Victoria represented on these committees. There would obviously, if in fact this is something the council approves, there would have to be a transition period, and we'd figure out those details, how to transition from what's done now into that kind of an approach. Second item that I think has to be done is we have to tape record every committee meeting that occurs. I've read a lot of these meeting minutes that come out of these committees. These meeting minutes are never designed to be a court reporter or verbatim discussions, but they're meant to be able to provide the public insights into what's going on in these committees. And earlier this year, unrelated to the open meeting lawsuit, one person resigned from the Finance Committee over allegations of the meeting minutes for the Finance Committee did not accurately reflect the discussions that occurred. I wasn't there. I don't know if the allegations are correct or not, but I will tell you that if we had a recording of those meetings, we'd be able to play that recording, compare that to the meeting notes, and we'd unequivocally be able to answer the question. Therefore, there are similar issues with other committees. I think every committee that the city has, we should audio record those. We have those audio recordings because they're large files. We keep them at City Hall and make them available to the public for anybody that wishes to come in and get a copy of them. Because of the actual electronic size, I don't know if we can load them onto the city website or pay a service like Dropbox or similar services to store them for people to get direct access, although I'd be open to that if we think that makes sense. The key from my point of view is that we record these meetings, we have them available. We continue with the meeting summaries. Those meeting summaries are designed to give people an idea of what goes on in the committees, and if they have more questions, they can always go to the full recording. So that's the second point, tape record all meetings. Third point, I believe that council rep, for every formal committee of the city council, the council rep that's appointed should provide formal reports back to the whole council. I know over the years where I've been watching the council, there's at times reports. There's sometimes more formal than others. Sometimes you never hear anything about committees that happen during that month. I would like to formalize that, make that a requirement. While there's no formal recommendation that would come out of a committee, I would think the council member that's assigned would provide a brief synopsis of what the committee is looking at. And when the committee actually does get to the point where they're going to make a formal recommendation to the council, I believe that committee should come in and present and make that recommendation formalized. I don't see that going on in the committees today. I'd like to see that implemented. And then finally, and Bob mentioned this earlier, and Bob, correct me if I'm wrong, I don't believe individual citizens that serve on one of the city's committee are directly responsible for the open meeting law or the Data Practices Act. But in an effort to educate them, we know the council members are. I believe that everybody that serves on a committee should go through at least an orientation provided by the city clerk, who is the responsible authority under the Data Practices Act. That can either be done by training materials provided from the league that the city clerk can take everybody through as a mandatory requirement to participate in a committee, or something that's provided by the city attorney that says, here's the requirement, so that the people that serve on the committees understand that the city council and the city as a whole is responsible for complying with these laws, and if they're serving on the committee, they're at least aware of those. Those are the four reforms I want to do across all of the committees, because I believe there's a lot of things that happen on the committee that don't necessarily get easily into the public domain. And there's questions sometime, like I mentioned on the Finance Committee, where things have occurred and we have no way to go back and either verify statements made after the fact or confirm whether the meeting minutes are correct or not. So with that, let me pause and ask the council for comments and whether or not they have any other suggestions for potential reforms.
Since I complained, I'll start. Thank you for, again, limiting your comments to what you would like to see changed. I applaud your comments in terms of transparency and bringing more transparency to the city. I think there are a number of things that we could do to enhance the committee process. But to go forward tonight with all of your recommendations, I kind of view this as a surprise with no heads up, and we really need to study these to understand what the ramifications are, both from a policy standpoint as well as a process standpoint. What does it mean from a staff perspective to implement this? And the normal process that we would use to discuss this would be to have a workshop and have an open discussion about all these individual items. And with a workshop, we might find that all or some of these could be implemented, or we might find that there's a process issue that poses a challenge. So my suggestion would be to have a debate, a discussion about this during a workshop.
Others?
I think in general, there's, probably very little that's concerning about any of these. There's maybe some upside. The one I guess I don't understand necessarily is, or I shouldn't say don't understand, but the precinct or the geographical basis. It's generally been the philosophy of the council, and I think this predates most of us who are here, has been to kind of take all comers. We encouraged as many residents as possible to get involved wherever possible, and I think turning away people is kind of setting the wrong idea. So I think, if you find you've got too many people and that becomes a differentiator, then, I guess I wouldn't see any problem with that there. I do want to, point out also that none of these committees or commissions have any decision-making authority, with the exception of Planning Commission being required by statute and having the ability to hold public hearings. A lot of times it's just regular citizens who want to get involved and help become part of the recommendation process. And I guess the one thing that I guess is just a a flag, and, we can try whatever we want, whatever we all agree to, and then see if it works or if it has or if it doesn't. And that is that, again, no decision-making authority. So the question is, are we going to chase people away? Are we going to make this feel like we're not welcoming input, that we're not being kind of open to regular people and trying to turn them into little bureaucrats who can cite chapter and verse, and they'll just decide it's not worth the effort. So I think reports make great sense, but I guess it's just a cautionary note about some of the other stuff that kind of gets overly burdensome on the citizen members.
Other comments?
Having been on the planning commission, I won't say much about that other than they have no authority. They do hold meetings and hearings, but they're subject to the council's decisions. Parks and Recs Committee, I've shown an interest in that one, and over the years, I don't think I've detected any kind of a problematic situation. The Finance Committee is basically a very detailed workshop committee, taking minutes would require immense concentration and quite a bit of talent and cost some money. And I've been on the Finance Committee, and we spend a couple hours, sometimes 3 or 4 hours, looking at detailed spreadsheets and reports and piles of paper and discussing different things and coming up with some consensus to pass on to the council. But it'd be very difficult. Recording probably would be the best thing. On the other hand, with the Finance Committee, I remember it was very difficult to get people to even be interested in the Finance Committee. I remember on the Planning Commission, there were some years we couldn't get anybody to sign up for the Planning Commission. You can say the same about the City Council. We had years when either no one would run or one person was running, and we had 2 open seats. So I'd be very worried about making it difficult for individual citizens to volunteer. And if there was a transparency issue, I was on the Finance Committee for many years, for 4 years. It was really transparent to me that there was a problem. So, I understand there's some concerns here coming from our mayor, and but this is a sudden variation. This is a town of 9,000 people. It's not a town of 25,000. We still depend on the fact that we need to find the talent where it is. In some neighborhoods, there might not be any talent. So, these volunteers are very valuable people, and we try to get the best ones we can. So, I don't want to do anything that's going to make this something that people that would volunteer and help the city this would have a negative impact on them.
All right, thank you, Tom. Tom?
As far as minutes versus recording, can you do just recording and not do minutes?
We would still need to have meeting minutes.
Okay. I would think recording would be a pretty easy, low-cost thing. I think that would solve a lot of these minutes types of issues. As far as, I don't think we're looking for any specific direction here tonight. I think maybe the thought process would be to direct staff to some of these thoughts and see if they can come up with some proposals. Now, I think that's kind of where we're going here. But as far as locations within the community. I could see where we could get lopsided on a certain committee, particularly Parks and Recs. Everybody wants trails. If the Park and Rec were overloaded on a particular neighborhood, that neighborhood, you could see where it could get a little bit more attention for those types of things. But as far as tonight goes, I think we're in agreement that maybe we're just looking for some direction. And
All right, thanks. A couple quick comments. My comments about the precinct were not meant to be absolute. They were meant to be, that's the desired choice. If we couldn't get somebody after, let's say, a specified period of time, let's say 60 days, something like that, whatever the council would like, then we would fill it from any other volunteers. I don't think any of these 4 items that I proposed are all that drastic or would cost the city. I don't know why. I didn't anticipate any citizens that would find any of these issues as that would dissuade them from volunteering to be on a committee. But I'm happy that if the council wants to go ahead and put this as a workshop before an upcoming council meeting to go over this in more detail and maybe work out a process, I'm not opposed to that. So, Lori, if there's consensus on the council, can we do that? If there's a consensus on the council, should we just schedule a workshop to dig into this further to see if we can't come up with something? Yes?
I can do that, Mayor.
All right.
Do we need to approve this?
We still have to appoint people, both council members to the committees, and then we have to talk about some of the actual citizen representatives on the committees as they are. Lori, what's the easiest way to do this?
So what we'd be looking for in terms of action is what's outlined in the proposed motion, appointments of the city council representatives to the finance committee, the park and rec, and a decision on whether someone is interested in serving on Victoria for a lifetime. That's the official action that I'm looking for. The other direction I would be looking for is those citizen representatives highlighted in yellow have terms that will be coming to an end as of March 31st. Typical process would be to begin advertising those positions following this meeting and accept applications through the end of February. I feel comfortable that we could go ahead with advertising those positions and still have the discussion regarding any changes and not have that affect that advertisement. So if the council is comfortable with that, I'd just like some consensus that we should go ahead.
Does that require a vote or just a discussion?
Yeah, just a head nod would be acceptable for me on that one.
The one comment, can we get this to scroll up so I can see the full list? Thank you. I don't have any opposition to that. If the council agrees, we can go forward. But I do want to make a comment. Is Mr. Ivansky, is he the gentleman that has not been able to attend the Finance Committee meetings?
Yeah, he is not. The other gentleman listed there, Mark Nettesheim, has attended one of the last 8 or 9 Finance Committee meetings.
Okay, so what I would like to, because of the fact that 1 out of 8, 1 out of 9 clearly isn't working, according to my understanding on the city ordinances, the city council can replace that gentleman since he's clearly not doing that. And is John Iverson in the room? John, I'd like to nominate you. I don't know the process to go through this. Would you mind coming up and state for the record your name and your address and whether or not you'd be willing to serve on the Finance Committee in the place of the one gentleman that's not attending?
Sure. John Iverson, 1032 Anthony Way, here in Victoria. I'd be interested in Finance Committee. Finance is my business, and numbers is my game. So.
Perfect, thank you. I didn't want to surprise the council with this, and I don't know what the process is. Do we need to go, does the council want to appoint him, or does the council want to discuss this?
Normally, we would see a resume and an application.
Yeah, and an interview process.
And an interview process and open it up to others that would like to participate.
So Lori, would you do that?
Yes, I would.
All right, so thank you, John.
Okay.
We'll just be interviewing for 2 positions for Finance Committee in March instead of 1.
Yeah, I would look for a motion voted on by 3/5 of the council members to remove Mark Nettesheim from the Finance Committee and declare that vacancy, and then we could advertise for both positions.
Okay, I'm confused. Who is the person that can't attend the meetings?
Mark Nettesheim.
Mark.
Okay, I thought I heard something different before.
Greg is just expiring, but he's been attending. Mark
Okay,
has not been able to make
I
meetings.
thought I heard reverse.
I would
Could be
hate
me.
to lose Greg's expertise. Greg is a tremendous asset to the city.
All right, so I make the motion that the council remove Mark Nedashine due to his inability to be able to participate in the meetings. Is there a second?
Second.
All in favor signify by saying aye.
Aye.
Hearing no opposition, we'll remove him and create that opening. As far as the committee, the council member representatives to the committees, I would like to propose that myself and council member Vogt participate on finance, and that council member Gregory participate on Park and Rec. And those are the only two committees, the official committees of the city council, correct?
Correct.
And we have not traditionally, Mayor O'Connor attended Victoria for a Lifetime, but he did that as on his own, not as an official appointment. Is that correct?
I believe he was officially appointed, but the code and the committee structure do not require a council representative to the Victoria.
If there's no objections to the alignment I propose, is there anybody on the council that has objections to that or would like to serve on the Victoria for a Lifetime?
I could serve, how often do they meet?
They meet once a month on I've got it in here.
I think it's the third Tuesday of each.
I fit the profile.
Would you be willing to serve on two committees?
I wish my wife still was here. Yes,
If you're reluctant, I can take finance.
well, I think the committee really appreciated the fact that somebody from the council was there. And that's just my sense. I didn't have any lengthy discussions. And so one of the questions I would have had is, what does the Lifetime Committee think about this? But we know.
The chair of the committee is in the audience if the mayor would like to ask him for comment. I've not specifically reached out.
Sure. Would you please come up, introduce yourself, name and address?
I'm Paul Asplund, 8425 Spruce Point here in Victoria, and I am the current chair of the Victoria for Lifetime Committee.
Perfect. You have any thoughts?
We would love to have Councilmember Vogt be a part of the committee. We do appreciate having some representation from the council with city updates and things like that.
Perfect.
Okay.
Both committees, or would you like just Lifetime?
I can handle it.
Okay. I make the motion that we appoint myself and Councilmember Vogt to the Finance Committee. We appoint Councilmember Gregory to the Park and Rec, and we appoint Councilmember Vogt to the Victoria for a Lifetime Committee. Is there a second?
Second.
All in favor signify by saying aye. Aye.
Aye.
Hearing none opposed, that passes.
Thank you. The final action that you may consider under this agenda item, you did receive an application to serve on the Victoria for a Lifetime Committee from Brad Johnson, a resident who lives on Marigold Circle. Typically, the Victoria for a Lifetime Committee interviews potential applicants and then forwards recommendations to the City Council. You traditionally do not interview those applicants. I have also received, after the agenda was published, an indication from the chair that Tom O'Connor, former Mayor O'Connor, would like to be appointed to serve on Victoria for a Lifetime as well. The committee has openings to accommodate both citizen appointments if the council is so inclined to make one or both of those this evening.
Yeah, what I would like to do is because there's some questions that I want to discuss with the full council in the workshop about the whole committee structure, that we have that first, and as part of that, as soon as we've had a chance to have that discussion, we revisit this. Is there any need that we have to appoint those people tonight, or we just start advertising?
Yes, I do not have a need or a deadline that those appointments would
All right,
need to be.
and just for the record, in case there's questions, I have no objection to our former mayor serving on the Victoria for a Lifetime Committee if he so chooses. That's not why I'm bringing this up. I do want to work with the council, though, and resolve this question about what kind of reforms, if any, that we put in place. Get that resolved first before we go and start considering applications for additional positions. So, any other comments on this from the council? Lori?
No, Mayor.
Okay. You want to introduce the last new business, please, Lori?
I will. Thank you. The last item is to discuss our agenda setting policy, and what I'd like to do is just start with what our current practice has been. If a council member or mayor has had an interest in bringing a new project or idea before the city council, they typically have discussed it with me and then brought it up under reports of the mayor and council for the entire council to react to the idea in general. And then if there is a consensus of the council that that's something that they would like staff to research and prepare for a future agenda item, that direction has been provided to me, and I manage the scheduling of those agenda items. Because we have a new council, I wanted to take the opportunity to check in on that item. There are, I loved Bob's analogy on snowflakes. There are as many ways to do this as there are cities in Minnesota. I did put together some examples in the event that you're interested in doing something different than what our past practice has been. Mostly I'm asking you this question for my comfort so that I know how to interact with ideas that are raised by individual council members. What we've been doing in the past, I think, has worked fine, so I'm not seeking any change, but I'm happy to accommodate and put together a policy that works for this council.
Thank you, Lori. I'd like to open up I don't think we need to spend a lot of time on this, but I want to at least let the council know why I asked Lori to do this. I attended my first training session already after the election, and one of the topics that was discussed, and this was given by the League of Minnesota Cities, Association of Minnesota Counties, and a couple of other organizations that help train newly elected officials and school board members, city clerks, et cetera. And this whole topic of agendas came up, and they're really in the training. I got a whole series of mixed messages, so I asked Lori to look at what is the standard practice. Does the city of Victoria have a formal policy? The answer is no. If anybody has a chance to read through these, you'll see that literally it's wide open. There's all sorts of different ways that different cities look at this, and there's no consistency. I'm not suggesting that we need to change anything that has traditionally been done by the Victoria City Council, but I just wanted to bring up the fact that I went to the training, and the training was contradictory, and then based on this information that Lori was able to research, there clearly is no standard practice, if you will. And so for the council, if the council has any thoughts about this, do we need something? I'm not saying we do, but I just wanted to have a brief discussion as to this specific topic of how we manage the agendas. So, council?
I had a chance to speak to Lori about this a little bit today. The existing, I'll call it a practice as opposed to a policy, is something that has been probably handed down since way before any of us. And I think the flexibility that it brings is beneficial, and that flexibility is a double-edged sword, which is to our benefit. Surprises aren't looked upon positively because we tend to need time to look at things and consider things as opposed to rushing things through. So surprises are things that get removed from the agenda. The approach that we've taken so far is one of bringing it up at the end of the meeting and having Lori consider that, what ramifications are in terms of staff time to bring it to bear, and then have her come back to us with, this is when I think we can get to it, and if we think it's higher priority, we can discuss that too. And I think that practice has worked well. To bring it to a more formal process, I guess I would be concerned that it might limit our ability to debate and discuss things. So those are my thoughts.
Other comments?
I kind of, yeah, it's an interesting question. I guess I kind of start from the position of what problem are we trying to solve? I didn't necessarily hear that there was a problem, so, more than willing to listen, but I wouldn't necessarily see a need to put more rules on ourselves unless we start encountering issues.
Either of the remaining Toms?
Have we, I'm looking to Lori.
My name is Jim.
You're an exception. has the citizenry complained about the way the agenda and the proceedings have been at council meetings where,
They have not.
so we have no formal complaints or agitation that relates to the way the agenda develops?
No, we do not. And just to add on to what you're asking, if a resident has suggested an agenda item, what I would direct them to do is to come under the open forum and to briefly present an overview, and then the council can further discuss and direct based on that. So there is a process in place for a resident to submit agenda items.
Tom Gregory?
I guess I've been at council meetings before where there have been a number of residents from a particular community where a development's been proposed, where they took time off of work and they showed up at meetings and they couldn't speak. And that left a lot of people frustrated. I think in going through some of these, I think at times we could suspend Robert's Rules of Order with a 3/5 vote and allow people to speak. Would that be the policy if we ended up with a room full of people that were concerned about a particular development coming through? Would you suspend Robert's rules to allow for a change? Is that how it would be?
I'm going to defer to the attorney on the question.
Mayor and Council, the practice has been on occasion to allow people to speak, although it hasn't been set up as a public hearing where folks want to speak on it. That's perfectly legal. That's not a problem. One caveat is one caveat I gave before about those quasi-judicial decisions, and it's not a bright line at all. My only concern about those decisions is if you have a public hearing and you take a bunch of evidence and facts in, and then you kind of close that and move forward but at the staff level and the item comes forward, and then you let more people speak, well, then the opponents to that really have a right to be there and hear that, and they didn't know they were going to, so you can get into a when is it over? I wanted to be there when the last words were going to get said. So, but other than that limited example, yeah, you can always take input from folks if you feel like it's appropriate. Again, parliamentarian mayor has to control the length of the meeting a little bit and decorum, but within those parameters, sure, you can take input.
We have endeavored, if I may, as staff to better delineate when public comment will be taken, what issues will be considered at what time and by which body, to be respectful of, certainly we understand that residents do take time off of work and away from their family to participate in public processes. So we will continue to try to make that delineation clear so people can be efficient with their time and their participation. That's important to us.
I think I'm getting a little confused here. It seems like there are a couple of different things that are getting wound together because the question of how things get on an agenda versus public meetings, open houses, public forums on specific issues. I think that is the perfect reason to have an agenda and to have Robert's Rules. If the agenda is published and other topics get put on and get a more formal discussion without being announced beforehand, the people who have interest in it don't have an opportunity to know that it's coming and participate, pro or against, doesn't matter. So I'm not sure that those aren't two separate issues.
And isn't there an agenda item related, or agenda issue related to OML and noticing meetings? That if we add things that are not on the agenda, that is a potential OML issue that we would have to recuse ourselves from the meeting.
Only if it's special.
Yeah, Mayor and Council, that's right. When you notice a special meeting, you can only talk about what you noticed the special meeting for. But what I'm hearing, and I think it's consistent with my understanding of how you've done it in the past, at the end of the day, you have a proposed agenda that's put together as it gets put together, but at the end of the day, you vote to approve the agenda. The council in the past has approved the agenda, and if an item has come forward too late, in some cases you removed it, and that problem that causes is people might be in the audience and want to hear about that, and it got removed. And on some rare occasions, I think items have been added to the agenda, and that concern is the opposite. People didn't know it was going to get added, and they aren't here, and so I'd like you to avoid changing the agenda, the proposed agenda, as much as possible. But there are times when it has to happen. So.
All right, I think I'll be able to effectively manage public comment when it comes up. It doesn't come up that often. Specific to this, again, I want to reiterate, I'm not trying to fix something that's not broken. But I've spent the last 2 months drinking through a fire hose, trying to learn all the responsibilities and going through budgets, meeting with city staff, going through training. And this is just one area that I could not seem to get consistent or defined answers. So I asked Lori to put this together. Well, the reason I can't get consistent or defined answers, I think, is self-explanatory in what we saw here as far as formal policy. I'm fine with keeping the existing process that the City Council of Victoria has used. But I did think that this was something that I wanted to bring up to the council to see if there's any thoughts, questions, or concerns. And based on what I heard, I don't think we have to make any changes from the standard practice, even if it's not a documented practice. I'm fine with that. So unless there's any additional comments from the council, I think we can move on. Council, any other comments?
No, good.
Okay, let's move on. Lori, reports to the city manager.
Just a few brief items, Mayor. I wanted to remind you that there is a meeting here on Thursday, January 12th. That is a neighborhood meeting for the 2017 street and drainage improvement projects. All of the affected residents have been invited by U.S. mail, and it is published on our website. Just a quick reminder. And then the other item of note that would be coming on your next agenda, there would be a call for a public improvement hearing on that street project. And you have looked previously at a sketch plat for a development called Waterford Landing. That's proposed to go to Planning Commission on January 17th, and then we would anticipate it would be on the January 23rd City Council agenda. I bring that up because I know there are a number of residents that have been following that project, and there is some of information available on our homepage. But just a heads up on those items coming before you. And that's all I have for you this evening.
Okay, reports of city attorney. Bob, anything else?
Mayor, council, it's very slippery out. Be careful.
Before, I'd like to make a few quick closing comments, but before I do, I'd like to give the council members a chance to, any comments, any reports? Nope. Then in closing, what I'd like to do is let everybody know I'm very grateful that the residents of Victoria chose me as their mayor for the next 4 years. When I had the campaign going, I put out that 7-point plan. It's my intention to work with the council and to implement those things I articulated in that plan. I will tell you that at this point, as you can imagine, I'm drinking through the fire hose and trying to learn all of these. Myself and Councilmember Gregory have already signed up for open meeting law and data practices training. I think it's late January. I think it's important given just the history of the city. And so I look forward to helping drive the city forward. For those of you that do know, you have my personal address. It's thomascfunk@gmail.com. Feel free to send me any comments that you want. And Bob, I want to make sure I understand one thing correctly, and that is if residents communicate with myself or any council member for that matter, those kind of communications can be withheld as private data, right? Because it's constituents trying to talk to the council, right?
Yeah, Mayor and Council, it is true that communications between any of you and a constituent is only public in the event either of you want it to be public. I guess the concern is, and the prior advice has always been, now that we have city assigned email addresses, we would prefer that you use those. We can't mandate that, but we would prefer that very much because that helps us to control, for city-related business, obviously. It helps us respond to data requests because it is possible, and it has happened, that data requests have been made for those kind of communications, and one or the other parties is willing to release it, and thus it would have to be released, and then we have to go to the individual council member, and it becomes difficult. So I would ask you to consider using the city's email. I can't compel you to do that.
Well, I will tell you, since this did come up, I will be using my city email account for any communications with Lori or city staff. I think that's the appropriate way, and I think the general process is I won't communicate directly electronically with other council members. That's all done through Lori, I think is the proper process. But as residents, feel free to get a hold of me at either email address. And one final note then, a number of people have asked me about the website and the Facebook page. Just for the record, for those of you that wanted to follow that, I've taken the website down. I will be taking the Facebook page down because when I originally set it up, not being a social media expert, I apparently set it up incorrectly. So I'm going to rebuild those at some point here in the near future where I can go ahead and put things out directly myself. So thank you, everybody, for coming tonight. Is there anything else that we need to do?
No further business, Mayor.
May I have a motion to
I
adjourn?
move we adjourn.
Second motion.
All in favor, say aye.
Aye.
Meeting adjourned.